Welcome to this video primer on Work Made for Hire. This video is intended as a quick primer on the basics of this area of copyright law. If you've ever worked as an independent contractor, you've probably seen this term in your contracts. If you've never heard of the term, however, you may be wondering what the concept of Work Made for Hire is all about. A good way to think about Work Made for Hire is that it's all about ownership and the rights that come with ownership. More specifically, who owns the copyright to the work of authorship when it's first created? The subject matter of Work Made for Hire is governed under Section 201 of Title 17 of the United States Code. Under Section 201, ownership of a copyright is dealt with in two main parts, Part A and Part B. Part A states that the initial ownership vests in the author or co-authors. Now, that's simple enough, and it makes a lot of common sense. After all, who else does a copyright belong to if not the person who created the work? But it turns out it's not that simple, because in Part B, it states that the employer or other persons with whom the work is, for whom the work is prepared is considered the author in case of the work made for hire. So the author is not necessarily the one or more human beings who actually created the work. But just what is work made for hire exactly? Work made for hire is defined in two parts in Title 17 of the United States Code. The first part defines work made for hire as the work prepared by an employee within the scope of his or her employment. The second part is related to 9 categories of specially ordered or commissioned work. To keep this all digestible, let's focus on the first part of the definition and then move on to the second. When you apply the rule in Section 201 to the definition of work made for hire, it basically means that the copyright in a work vests initially in the author or co-authors of that work. But who are the authors? Except for special situations, the authors are either the person or persons who actually created the work, or the employer of those persons. In the slide, the round rectangle represents the work of authorship, and the little figure represents the author. The green arrow represents the copyright vesting. For a single author who has created a work outside the scope of any employment relationship, the copyright to the work originally vests in himself or herself. For example, if you're a songwriter and you wrote a song, you are automatically the original owner of the copyright to that song. The copyright is originally vested in you. For co-authors of a joint work, the copyright vests in each co-author. Getting back to our song hypothetical, if you wrote and recorded a song with someone else, then you two are co-owners of the copyright to that song. However, if you are an employee of Sony Music, for example, and you wrote a song because it was within the scope of your job to do so, then Sony Music is considered the author, and the copyright originally vests in Sony Music alone. In each of these situations, the vesting occurs automatically, with or without a contract, with or without registration of the copyright. Contracts are still recommended, however, at the very least to define the scope of the employment, or to define the rights, relationships, the duties among the co-owners of the joint work. Recall that there is a second part to the definition of work made for hire, and that is 9 categories of work that is specially ordered or commissioned for use, as a contribution to a collective work, as a part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer materials for a test, or as an atlas. Now, you might have trouble remembering all 9 of these categories. But the most important thing you need to remember, however, is that in the second part of the definition of work made for hire, there is a written instrument requirement. Notice that unlike the first part of the definition, which is in the context of an employer-employee relationship, here a signed written agreement is required for the work to be considered work made for hire. For your convenience, shown here is a table summarizing with which person the copyright will vest and whether a contract is required. At this point, you might ask if there are any substantive differences in the copyrights acquired by the way of assignment versus copyrights obtained as a work made for hire. The major differences between straight assignments of a copyright versus work made for hire are summarized in this table. As I've mentioned before, in a work for hire situation, the copyright is vested automatically without a need for an explicit assignment. This is obviously advantageous to the employers because no additional paperwork is necessary to effect the assignment of the copyright. You might ask if there are any substantive differences in the copyrights acquired by assignment versus copyrights obtained as a work made for hire. The major differences between the straight assignments of a copyright versus work made for hire are summarized in this table. As I've mentioned before, in a work made for hire situation, the copyright is vested automatically without the need for an explicit assignment. This is obviously advantageous to employers because no additional paperwork is necessary to effect the assignment of the copyright. For a straight assignment, the duration of the life of the copyright is the life of the author, plus 70 years, or the last living co-author plus 70 years in situations of co-owners. In case of work made for hire, is 95 years from the date of the publication, or 120 years from the date of creation, whichever is shorter. Please note, however, because the laws regarding the duration of copyrights for works that were created prior to 1978 are complex, I've limited this table here to works created on or after January 1st, 1978. If the work is a work of visual art, the author of the work retains certain moral rights under the Copyright Act. However, under a work made for hire situation, the creator of the work will not have such rights. Lastly, and perhaps most importantly, assignments and licenses to copyrights can be terminated either by the author or others designated under the Act. In a work made for hire situation, however, the employer is considered the original author of the work, and as such, the copyright of the employer possesses cannot be terminated by another party.